by the United States that are outside of its sovereignty: independent nations, separate sovereign nations in free association, and international and regional organizations. A U.S. territory that becomes an independent nation is outside of U.S. sovereignty. Its sovereignty is separate and apart from the United States. It then possesses its own nationality and citizenship. This ends application of the U.S. Constitution and federal law as the supreme law in the territory, and U.S. sovereignty ends. Relations between the newly independent country and the United States are governed by treaty and international agreements to which both parties are signatories. In the case of a territory that becomes independent but is not ready or able to carry out all the functions of national sovereignty, it may enter into a treaty of free association with its former nation or a third nation. This mutually agreed upon treaty of free association is not guaranteed or permanent under the U.S. Constitution. If free association is to be non-territorial and non-colonial, it must be terminable at will by either party. Free association is a form of independence and does not constitute a permanent union. Any rights granted to citizens of the freely associated state, such as unencumbered travel and residency, are not constitutionally permanent or guaranteed. In addition to defining political status, the U.S. Constitution empowers Congress to either grant or deny citizenship and nationality to residents of its territories. When granted, this is referred to as statutory citizenship. Our constitutional graphic is helpful in understanding the differences. Just as there are distinct realms of political status within or outside of the U.S. Constitution, so too are there two realms of nationality and citizenship: constitutional citizenship and statutory citizenship. The second point is that nationality does not automatically convey citizenship, but you cannot have citizenship without nationality. First, let us look at constitutional citizenship. Under the 14th Amendment to the U.S. Constitution, a person born or naturalized in a state of the Union has U.S. nationality and citizenship, as well as local citizenship in the state of residency. It is lost only by voluntary, intentional, and unconditional renunciation. Constitutional citizenship is guaranteed, permanent, and irrevocable. It is unconditional, and within it, nationality and citizenship are the same. Congress may also extend U.S. citizenship to persons who do not otherwise acquire it. Examples of this are persons born overseas of U.S. parents or persons born in a U.S. territory. Citizenship so granted by Congress is called statutory citizenship because it is created by a law. This citizenship is permissive, subject to conditions, and its conferral may be terminated by Congress at any time. In statutory citizenship, the terms nationality and citizenship may or may not have the same meaning. For example, Congress has the power to extend U.S. nationality to individuals or groups by treaty or federal law, but to withhold U.S. citizenship. This is what Congress did in the case of Puerto Rico from 1900 to 1917 and in the Philippines from 1900 to 1945. U.S. nationals born in those territories during those periods had U.S. nationality with a local citizenship status defined by federal law. When nationality ends, all forms of citizenship under U.S. law also end. Persons born in a territory with U.S. citizenship will no longer acquire that status if the territory does not remain under U.S. sovereignty. There is no vested right to U.S. citizenship granted by laws enacted at the pleasure of Congress, just as there is no vested right to a political status created at the pleasure of Congress. Upon succession to separate sovereignty, persons born in a former territory are aliens under U.S. law. As such, the citizens of the new nation are eligible for immigration and naturalization on the same basis as other foreign citizens. Any special privileges granted by Congress, by law or treaty, to citizens of a former territory are not permanent or guaranteed. The movement of U.S. territorial people towards a permanent political status must recognize the tenets of the Constitution. All matters determining the sovereignty of U.S. territories and the citizenship of their people are specifically provided for in the U.S. Constitution. This document is the empowering and limiting authority by which Congress governs territories and possessions. Its provisions are the benchmarks against which any claim to permanent sovereignty and American citizenship must be gauged. I thank you for your attention.